Hey students, today I start before you Constitutional Foundations of Criminal Justice Administration. I am Professor B.B. Pandey, Chair Professor of Criminal Law in NLUD. I've been teaching criminal law and criminal justice for over 52 years now. Let me take you to the first issue of introducing the subject that we plan to discuss this morning. A.G. Noorani, in his book, while writing the foreword on Handbook of Human Rights and Criminal Justice in India, he said, while every work on British constitutional law discusses at length the status and powers of police, books on constitutional law of India ignore the profound importance of police in a polity governed by the rule of law. Now, this kind of disconnect continues even in the textbooks of criminal law too, which scarcely recognize Constitution as the source of criminal justice administration, directives and principles. Now I will take you to the learning objectives of this course. The first learning objective is to locate and expound the constitutional norms that relate to criminal justice administration. The second learning objective is to present a comprehensive understanding of the substantive, procedural and adjective laws issues that are shaped by the constitutional guarantees. And the third learning objective is to create an understanding of the large-scale non-compliance with the guarantees in reality. The fourth learning objective is to understand the role of judicial rulings that impact the criminal justice administration realities. Now, I will tell you about the constitutional mandate to recognize the foundations. The Constitution in 1950 lays down clearly in Article 372 that the existing laws, that is substantive criminal law and procedural criminal laws, shall be adapted by our society. This is the source of power from which the state functionaries would derive their powers. However, such a blanket power conferred is balanced by Article 13, Clause 1 and 2. Article 13, Clause 1 says that all the existing laws should be consistent with the fundamental right that is Part 4 of the Constitution. And the laws will be void to the extent of any inconsistency with Part 4, Part 3 of the Constitution. Similarly, 13.2 says that all future laws shall have to be consistent with fundamental rights, and if they abridge or abrogate a fundamental right, they would be void from the beginning. Now, the 6 constitutional guarantees that can be described as the constitutional foundations are a right to life and personal liberty, a right against diverse modes of acquisition, a right against indiscriminate arrest and lack of legal defense, right to equality, entitlement to equal justice and free legal aid, and The sixth is constitutional right to judicial remedies. Now, if you talk of these constitutional foundational 6 issues in a detailed analysis, as per Article 21, every person, a citizen or a non-citizen, is entitled to right to life and right to personal liberty. However, the state may deprive a person of the aforesaid rights by showing that they have done so after following the procedure laid down by law. After 1977, the legal procedure also needs to be shown to be fair and just and not any legal procedure. Now I go to the second foundational right, that is special right of persons facing accusations. Article 20 has special relevance to an accused, namely 3 kinds of rights that are assigned to the accused: no behavior to be designated as crime or offense without any prior law to that effect, ex post facto legislation; no prosecution or conviction for the same offense twice, that is rule against double jeopardy. Third, no person shall be compelled to be a witness against himself, that is compulsion against self-testimony. Now, the second important right that is given, that can be described as constitutional foundation, is right against indiscriminate arrest. It is very interesting that the constitution makers were aware that state power interferes with the liberty of the citizen or non-citizen through the power of arrest. Therefore, they provided in Article 22, Clause 1 and 2, special measures for protection of arrestee. Article 22, Clause 1 says, the ground of arrest must be communicated to the arrestee. The second is, arrestee shall not be denied his right to consult and be defended by a lawyer of his choice. And the third safeguard is, person in custody shall be produced before a magistrate within 24 hours. Now, the fourth right, or the fourth constitutional foundation, is right to equality. Article 14 states the general law of equality in wider sense, and that contextualized in criminal justice administration term means no discrimination between one criminal and another, both for the purposes of criminalization and operation of the processes. 2. No discrimination principle shall in respect to matters of extending protection as well. Third, however, the provision permits reasonable classification that is based on intelligible differential test. Now, from this you flow into entitlement to equal justice and free legal aid. Though Article 22(1) guarantees a right to counsel to every accused, the 42nd Constitutional Amendment in 1976 added 39A that directs the state to ensure that operation of the legal system shall be based on equality of opportunity and access to justice for all. Special obligation is there on the state to organize legal aid for the poor and resourceless to offset access to justice disadvantages. Now you come to the last of the constitutional foundations, and that is constitutional right to judicial remedies. The rights guaranteed in Part 3 and 4 acquire meaning only when they are backed by remedies, such remedies are provided by. The three remedies are that Article 32 that guarantees remedies in the Supreme Court, likewise Article 226 and 227 guarantees remedies in the high courts, and such higher courts have powers to issue directions, orders and writs for the enforcement of the fundamental rights. Now we go on to locate these constitutional foundations in the statutory laws. Two major categories of statutory laws, namely substantive criminal laws and procedural criminal laws, are the substantive criminal law is the Indian Penal Code 1860 and other central and state penal statutes. The procedural criminal laws, the Code of Criminal Procedure 1973, superseding the 1898 Criminal Procedure Code and the Indian Evidence Act 1872. The philosophical foundations of the Indian Penal Code were, as described by Lord Macaulay, the chairman of the Penal Code Drafting Committee, in these words: uniformity when you can have it, diversity when you must have it, but in all cases, certainty. This is what Lord Babington Macaulay said. Now, this kind of quest for certainty in the framing of the Penal Code was ultimately, Macaulay succeeded in presenting a code that had a uniform and universal character that applied equally to the rich and poor, the privileged and unprivileged. Thus, the Penal Code endorses this very strongly the equality principle that was later on incorporated in Article 14 of the Constitution. Criminal procedure largely impacted the philosophy of constitutionalism. Like the Penal Code, the constitutional foundations have impacted the criminal procedure law in much more profound manner because the Criminal Procedure Code of 1898 applied in this country only in the 1950s and 60s. And after, in the 70s, already they had started the first phase of criminal justice reform, giving rise to, on the basis of constitutional push, the 42nd report of criminal procedure reform by the Law Commission of India that led to the Criminal Procedure Bill of 1971 that led finally to Code of Criminal Procedure in 1973. At the time of introducing the bill in the Parliament, the officially three considerations lay at the root of Criminal Procedure Bill. The three considerations were speedy disposal consideration, due process consideration, and fair deal to poorer sections consideration. These three considerations constituted the foundation of the criminal procedure law. Now, the foundations were clearly reflected in the following seven considerations, six significant features. The features were clear demarcation of stages and the functional allocation of procedure tasks to divergent agencies, then ensuring speedy criminal proceedings, safeguard provided to pre-trial stage rights, Then right to pre-sentence hearing and focus on reformative sentencing, special measures for indigent accused, and recognition of victim justice ultimately. Now, the sharper demarcation and recognition to the diverse stages of criminal proceedings has itself can be discussed in terms of criminal justice is dependent upon the conjoined functions of diverse agencies. Though all the agencies are interested in investigation, prosecution, and trial of crimes, but each of the agency enjoys a fair degree of functional autonomy and independence. Keeping in view the objective of autonomy and independence of every agency, the new code has for the first time recognized the principle of separation of investigatory and prosecutorial power. Continuing this frame, I would say that such a separation led to the incorporation of Section 24 and 25, allocating distinct functions to prosecution functionaries that should be independent of police. The underlying idea has been supported by the Procedure Amendment of 2005 that has added Section 25A that empowers the state to establish a Directorate of Prosecution and create a hierarchy of prosecution functionaries. I was talking about speedy criminal proceedings as one of the leading features of the Code of Criminal Procedure 1973. The new code has stressed expeditious proceedings under the following measures in particular. Section 57 prohibits police custody beyond 24 hours without authorization from magistrate. Then Section 167(1) says that in case the police requires the accused to be kept in custody beyond 24 hours, it should make an application to that effect for remand. Then Section 167(2) says the magistrate can grant two kinds of remands, namely police custody remand and the second is judicial custody remand. Now, then the fourth issue on speedy criminal proceedings is police remand can be given only in the initial stage to a maximum of 15 days at a time. But judicial remand may be for a longer period, only 15 days at a time. The fifth issue is remandee may remain under trial up to 90 days in cases of offences punishable with more than 10 years, and in all other cases the maximum period of remand shall be for 60 days only. After the expiry of 90 or 60 days, the under trial in custody shall have a right to be released on bail. Now, then we come to pre-trial stage rights of the accused. Power to arrest and search and seize and interrogate person are the means by which the executive operates in the pre-trial stages. Since most significant encroachment on the freedoms of the accused is effected by the exercise of power of arrest, Section 49 to 60 that enumerate rights of the accused are placed immediately after general powers of arrest as follows. That right to be informed of the grounds of arrest. Then 50A says arrester's obligation to inform a nominated person of the time of arrest, the fact of arrest, and the place where the arrestee is kept. Section 53 gives medical examination, right to medical examination to the arrestee. Then arrestee not to be released without legal proceedings, Section 59 says. Then formalities required before arrest This has been an important change. Section 41A, 41B, 41C and 41D, which clearly says that the law of arrest, particularly in cases of offences punishable with less than 7 years imprisonment, needs to be rationalized. Therefore, Section 41A lays down all the rationalization conditions. 41B puts the police to undertake formalities before arresting and exercising the power of arrest. 41C, duty to set up district level control rooms and display details of arrestee in the district level control rooms. And 41D gives to the arrestee the right to meet an advocate during interrogation as well. So the right of legal aid right from the interrogation stage starts as per 41D. Now, the other right is a right to pre-sentence hearing and obligation to award reformative sentencing. New code underscores reformative philosophy and shifting the focus to the circumstances relating to the criminal, that is known as mitigating circumstances. Such shift is reflected particularly in following measures. After recording conviction, the accused is given a right to get pre-sentence hearing under section 235(2) and 248(2). And before passing of the order of sentence, the court is obligated, because of sections 360 and 361, to pass reformative sentence, such as under the Probation of Offenders Act or under juvenile justice law. And section 361 says there is a mandatory provision that court shall give the reasons for not giving reformative sentence every time. Now, finally, recognition to victim justice. The Post-Malimat Committee 2003 developments have been reflected in Amendment 2005 and Amendment 2009, which have made these significant incorporation in the written law about definition of victim under section 2WA, victim's special right to appeal under proviso of section 372, victim's inclusion in the plea bargaining, section 365C, victim's special right to receive compensation and relief under 357A, 357B, and 357C, and then penalizing non-treatment to victim by medical practitioner under section 166B of the IPC. Then you come to, finally, to the role of higher judiciary in interpreting and implementing constitutional foundations. The higher judiciary in India has played a very significant role in making the constitutional foundations a live issue by, particularly in these seven areas. One is higher judiciary, particularly the Supreme Court and Higher Court, have significantly in the interpretation and implementation of constitutional guarantees, both through the final appeals and interventions under Article 32, made the following important rulings, such as role in significantly reflected in the following rulings. The 6 or 7 rulings are, which we have discussed here: constitutionality of death penalty, criminalization of attempted suicide, decriminalization of consenting adult homosexuality. These 3 are changes or constitutional interpretations by the courts in substantive law areas. The remaining 4 fair trial requirements, essentials of fair trial. 5th is compliance with amended law of arrest. The courts have been very, very serious about that. And 6th is equality under criminal justice administration. That has also been very, very strongly reflected in 2 apex court rulings. And finally, proactive delivery of custodial justice. This is again a very important shift in judicial practice or judicial adjudication, style of judicial adjudication. I'll discuss briefly limiting death penalty sentencing. Right from 1974, Judiciary continued to limit the use of death penalty sentencing. However, 2 recent rulings have taken the death penalty limitation to a new high. The 2 rulings are Shatrughan Chauhan, 2014, 3 Supreme Court cases at page 1, as 5-judge bench decision of the Supreme Court, in which 15 petitions filed by people who had been awarded death sentence, and all the 15, their mercy petitions had been rejected. And the Supreme Court decided in this Shatrughan Chauhan's case that the rejection of mercy petitions after a long delay amounts to violation of constitutional right guaranteed under Article 21. Therefore, the court almost revisited its own earlier decision in which they had awarded death sentence, but because of delay at the executive stage, they have reverted and commuted the death sentence to life imprisonment. The second important shift has come, important ruling on death penalty, is the Muhammad Arif case, in which the Supreme Court bench again of 5 judges laid down that the earlier law which gave order 25, Rule 13 of the Supreme Court rules of 1966, which had authorized the Supreme Court that in case of review petition, every time oral hearing may not be given, not necessary. And therefore that order of the Supreme Court rules had been constitutionally upheld earlier. But again, the challenge from 6 petitioners in this Muhammad Arif case was answered in favor of the petitioners. The court held in Muhammad Arif case that because of the special nature of death penalty, the sentence should, this kind of bar on oral hearing, even in review petitions, is violative of Article 21 of the Constitution. Therefore, all the cases which have been denied oral hearing at the review stage will be heard by them again. This has made a very significant inroad into awarding death sentence, and some of the cases which are pending have been almost reopened because of Muhammad Arif ruling. Now, the second issue in which courts have made a very important impact is questioning criminalization of attempted suicide. Right in the 1980s and 90s, the Indian courts have been very active in following the lead given by the Western countries, which have abolished attempted suicide as an offense, like UK 1984. India, many courts in India, particularly the Delhi High Court and other high courts, had given rulings saying that this section 309 is an obsolete provision that must go out of the statute book. Now, in the Supreme Court ruling in Rathiram's case in 1994 clearly laid down that section 309 is violative of constitutional guarantee under Article 21. Now, this, unfortunately, later the judgment of Gyan Kaur's case in 1996, a bench ruling, has taken a step back by saying that 309 is not unconstitutional, except in rare cases therefore, they have taken it back to now the third area of substantive law which has been examined by the judiciary is decriminalization of voluntary adult homosexuality. Adult homosexuality has been in question, and Nas Foundation decision of the Delhi High Court held it unconstitutional, violative of Article 21, Article 14. But unfortunately, in Suresh Kaushal's case, the Supreme Court in 2014 held that this law is not unconstitutional. So we again go back to the conservative position upholding the constitutionality of Section 377 of the Penal Code. Now, essentials of fair trial is the fourth important issue on which the Apex Court has given a very important ruling, Mohammad Hussain versus MCT of Delhi, in which the issue was this case becomes important because on the one side, delay in disposal is also an essential of fair trial. But fair trial also includes that the accused should have right to cross-examine the opposite witnesses, right to a counsel, right to a non-prejudiced hearing, etc. And finally, one of the accused, Mohammad Hussain, who was denied all this at the trial stage, right to cross-examine, right to have a counsel, was ultimately acquitted by the Supreme Court, and Supreme Court ordered retrial, and finally in the retrial also, and ultimately the accused was deported back to Pakistan, though he was involved, allegedly involved, in a terrorist offense. Now, recently, the Supreme Court has given its ruling on requirement to strictly comply with arrest law, and the amended arrest law in Arnesh Kumar's decision. Arnesh Kumar was the state of Bihar, 2014 decision. The court held that this requires the police as well as magistracy to apply its mind to arrest law which has been in the statute book, and this will apply not only to 498A case of arrest, but will apply to all the cases of arrest where the arrest is for an offense or less than 7 years imprisonment. Now, the last section in which we discuss the proactive delivery of custodial justice, this is part of Bhim Sen order passed by the Supreme Court on 5th September 2014, in which a bench of the Supreme Court said that this provision 436A, which had guaranteed in 2005 a right to the person in custody for half the period of the maximum sentence for which the offense was punishable. If he has spent half the period, he has a right to be released on bond instead of bail. Now, this was because of the reactive nature of judicial functioning. This right was rarely enforced in case of resourceless and the poor person in custody. And the Supreme Court in this case said that the jurisdictional magistrate, the sessions judge, will be under an obligation to visit the prison every week, 1 day a week, and find out who are the cases in which they have spent more than half the period, and pass an order in the prison itself. This makes judicial function proactive, and this is what should be the beginning of a new dawn for our criminal justice administration, changing and coming in tune with the constitutional foundations. I have discussed in these three broad areas what are the constitutional foundations, then what is how they are reflected in the statutory laws, and then how the judiciary is trying to give them a new meaning and show that the constitutionalism should impact the criminal justice administration really at the ground level. How much of it has happened, how much of it needs to be done, this you will be able to guess when you see the match between the constitutional promise and the ground level realities. I think this will be the most exciting contribution of this new course, which will link the Constitution and the criminal procedure law and the substantive criminal law into a kind of linked harmony, which will be in the best interest of every member of the society, not only the accused, but the victims, the community, and ultimate happiness of the society. Thank you very much.